Hello, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to actually get to you about the ATF rule as it relates to those who are engaged in business. But you see, this is the rule right here, and I'm actually going to get through all of it before we do the first video on that. But I do want to talk to you about another very, very important area, an area that I think we need to start focusing some energy as the 2A community, because we have seen in this post-Bruin Enlightenment era where we have opportunities to actually advance Second Amendment protections. And not really so much advance, but as much as to restore them back to what our founders actually intended. One of those areas comes with this goofy little concept where our constitutional rights stay with us at all times unless it's our Second Amendment rights, and then we travel to certain states, and then we have absolutely no ability whatsoever to ever exercise our Second Amendment rights. What state would be so stupid as to do that? That's right, we're talking about California. Now, they're not alone. They're on a very short list. New York and Hawaii being also two states that literally will not allow a person to exercise their Second Amendment rights at all inside their state unless they happen to be a resident of that state. This is an area that I think we can make some significant advancements in protecting the inalienable rights of Americans everywhere. So today, let's talk about another suit that I'm really excited about. Hope you are as well. So today, let's spend a few minutes and let's talk about how this will be the Second Amendment's next big battlefield. Okay. Now, we have talked about this issue before. California, New York, and Hawaii. Three states that we know are incredibly anti-Second Amendment. How anti-Second Amendment are they? They're so anti-Second Amendment that the only people who have a snowball's chance in hell of ever actually being able to carry a firearm legally inside that state are residents of that state. That's right, because the only individuals that can actually receive a concealed carry license from that state have to be in-state residents, and those three states do not honor any type of reciprocity agreement from any other state. So think about that. Hawaii would not even honor the concealed carry license from a state such as California, where it's virtually impossible to get one anyways. Now, can you think of any other constitutional right? You know, your First Amendment right to speak freely or go to whatever religious organization you want, your Fourth Amendment right to be free from unreasonable searches and seizures, your Fifth Amendment right to not have to incriminate yourself, your Sixth Amendment right to counsel, your Eighth Amendment right to be free from cruel and unusual punishment. Do any of those rights just suddenly vanish the minute you cross a state line? Of course not. Of course not. That's not how America works. Well, at least that's not how America was meant to work. But when it comes to the Second Amendment, apparently there is the problem. Today, we're going to talk about the case of Hoffman v. Bonta. It is a case brought to us by our good friends at the Firearms Policy Coalition. Yes, we will put a link down below so that you can show them some love. Now, this is not the first suit to challenge this. There are multiple other suits, and we have already done a series of videos because every time a suit is filed on this, we're big fans of it. Because again, as I mentioned, I cannot fathom any other constitutional right that you suddenly lose when you end up in a different state. In fact, even if you're forced to live out of your home state, you still get an absentee ballot, you still get to vote, right? But God forbid you want to actually exercise your right of self-preservation. Now, the Firearms Policy Coalition has filed this case in the United States District Court for the Southern District of California, a wise move. There seems to be a lot of traction. And I should point out that all of the individual named plaintiffs are former residents of California who at one point did have a California concealed carry license and now reside in other states, and they have already obtained concealed carry licenses in their new home states and have in some instances also obtained out-of-state carry permits such as from Arizona or Utah. But hey, no dice when it comes to the state of California. How does the Firearms Policy Coalition frame this issue? This ban is unconstitutional. Individuals like plaintiffs do not lose protection of their rights under the First Amendment speech or religious clauses when they cross state lines, nor do they lose their protection under the Fourth Amendment's prohibition on unreasonable searches and seizures. They likewise do not surrender their Second Amendment protections when they travel outside of their home state. California's prohibition on non-resident carry violates Second and 14th Amendments to the United States Constitution, as well as Article 4 of the same. This court should enter a judgment that declares California's non-resident carry ban unconstitutional and enjoins defendant and all those under defendant's supervision, including the sheriffs, from enforcing the residency requirement for carry applications with respect to otherwise qualified individuals who are not California residents. So I want you to understand here that the remedy that's being requested is not strike this law down and everybody in California and everywhere around the United States can just carry freely in California. No, that is not what the plaintiffs are asking. What they're asking is that the portions of the law that prohibits anybody who is not a California resident from applying for a concealed carry license, and the fact that the state of California refuses to offer any reciprocity, those two are the problem there, and those are the parts that need to be enjoined. Now, California will counter that, well, we actually do offer out-of-state permits, but those are incredibly limited permits and only for people who are conducting business actually inside the state of California. And it actually has even more conditions than that attached to it. As FPC wisely points out, California's carry licensing regime is closed off to non-residents. California requires that an applicant either resides in for a 2-year license or has a principal place of business or employment within the local permitting jurisdiction, with the latter being only a 90-day limited license valid only in the county in which the license was originally issued. As a result, California law provides no path for non-residents to obtain the license necessary to exercise their constitutionally protected right to bear arms in public for lawful purposes without running afoul of the state's broad statutory scheme that works a total ban on carry generally. Now, we know where this argument is going, is that, number one, does the plain text of the Second Amendment cover this activity? Well, we're talking about the right to carry firearms, bear arms, so yes, it is, of course, covered by the text of the Second Amendment. Therefore, the state of California is going to have to justify some type of historical analog, probably beyond gunpowder storage or Bowie knives, California, just want to point that out, that would say that we as a society have generally accepted people losing their otherwise inalienable rights merely because they cross the state line, because that's the historical analog we're looking for here. And as FPC points out, it is thus the state's burden to affirmatively prove that its firearms regulation is part of the historical tradition that delimits our outer bounds of the right to keep and bear arms. We are not obliged to sift through historical materials for evidence to sustain the statute. This is the respondent's burden. And of course, California cannot meet that burden because even in the Second Amendment world, okay, there is no right where historically you magically lose it by crossing a state line. Case in point how ridiculous this would be. If this were the case, when I resided in either Spokane, Washington, or Pullman, Washington, back in the day when I was doing higher education, okay, there was many a times where I would frequent Idaho, Moscow, Idaho, or Coeur d'Alene, Idaho, depending on where I was coming from. Are you to suggest that when I was temporarily in the state of Idaho, I had no constitutional rights, but fortunately I received them all back once I crossed the state line? Obviously, that is not how it works. But you see, in addition to that, and this is why I think that this argument has significant teeth, because not only is there a very clear Second Amendment violation here, okay, there's a massive violation of the Privileges and Immunities Clause found under Article 4 of the United States Constitution. What exactly is that? Well, as the plaintiffs point out, the Privileges and Immunities Clause of Article 4, Section 2 of the U.S. Constitution provides, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Really, shockingly, this allows us to actually have some uniformity in our rights and privileges as we move from state to state, as FPC wisely points out. The founders and framers understood the importance of ensuring that citizens could freely exercise their fundamental, constitutionally protected rights in each and every state in the Union. Those who come under the denomination of free inhabitants of a state, although not citizens of such state, are entitled in every other state to all the privileges of free citizens of the latter. That is, to greater privileges than they may have been entitled to in their own state. And again, this is important for how we live as a free society. Again, as the plaintiffs point out, according to the Supreme Court, the right to be treated as a welcome visitor rather than an unfriendly alien when temporarily present in the second state is expressly protected by the text of the Constitution via the Privileges and Immunities Clause. So, why do I like this issue so much? Because there are two ways to skin the cat, and you only need to actually accomplish one of them. Number one, we know, according to case law, the Second Amendment is applicable against the various states because it protects a fundamental right of citizens. Moreover, the Supreme Court recognized in Bruin that the Second Amendment's plain text thus presumptively guarantees a right to bear arms in public for self-defense. That is the constitutional mandates that we live under. And therefore, what the state of California is doing, although they are not exclusive to this, is in direct violation of the Second Amendment's mandates. But in addition to that, this action clearly violates Article 4, Section 2 of the United States Constitution under the Privileges and Immunities Clause, which guarantees the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So this case has a tremendous amount of potential. It is filed in the right jurisdiction. The plaintiffs here, Firearms Policy Coalition, is asking for declaratory judgment. Basically, hey, declare the law on its face is unconstitutional, and then permanent injunction. Now, again, this wouldn't just free California to everyone now as constitutional carry. That is not the remedy that's being requested here. However, the prohibition against out-of-state residents applying for concealed carry licenses, and potentially the prohibition that California places on reciprocity for all other states. That is what the Firearms Policy Coalition is trying to strike down. The case, once again, is Hoffman v. Bonta. We will link up the complaint down below so that you can geek out on it for yourself. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.